We're definitely doing that again. Hello, everybody. There it goes. All right. I love that. The deafening fade out there. Amazing. Whoever that sound engineer was, I really got to thank him for that. I also don't know if you can hear the way I do. My dad sort of, I call it grunts, but for lack of a better word, musicians, sometimes piano players. Lionel Hampton was always famous for this. Sometimes when they're doing their thing, they make physical noises as well, and so I can definitely hear my dad doing that in the background when I got the headphones on, the cans here. So I hope you can do the same, because I don't know, it reminds me of being a teenager and having him practice above my room. Yeah, so I understand that not everybody gets the pleasure out of that. Is not universal. Let's put it like that. But hey, it's okay. Here we're all at. Jello again. This has been Hitchcock Cross talking to you today. Starting with a little levity because we're gonna get serious pretty quick. Lee, in fact. Yeah. So what I would like to talk about today is basically another ALJ John Gelhard routine here. This, I think we've now hit rock bottom, but we'll see what happens. And the reason that I say that is this: you all have seen me stick up for all sorts of discrimination, and you've seen me get a bit passionate lately about just completely unnecessary and irrelevant religious comments made by this judge. And I think we've also seen me get, worked up, for lack of a better word, even though I'm the one describing my own actions and would hope I'd have a better word, but here we are. We've seen me stick up for stating what the law is, the law. Okay, and that in good or bad, the law needs to be, we all have to be honest to the law, just like we have to be honest to the facts when we're advocating under license to a tribunal. That's what we have to do. So here, though, I think we're at at a stage even lower than that in terms of conduct, but something that I think that I find to be even more serious. And I want to stay away from words like enrage or that make me angry or anything like that. And I mean, to the extent that that's true and that may be a byproduct of all that, I think we should acknowledge that. Great thing to do with bias at this point is we're at least trying to acknowledge them. Whether what we're doing after that is probably a next step, but I'm saying that I'm going to put that off to the side. Okay. I mean, I think that it does, because you have to understand that I'm not just in the hair club for men, I'm almost a customer, right? I am not just an advocate here. I'm also a citizen of the state of Wisconsin who wants to have all their laws enforced and wants to have bureaucrats who would enforce those laws. And I shouldn't say wants, demands. That's the right word, demands. Those that quality, that standard. And when a attorney who's working for the governor of the state of Wisconsin, an attorney working for Tony Evers, basically is told what the law is, acknowledges it, and then refuses to do it for some reasons that they think I don't know why. I mean, I don't know if it's I don't know what their motivations are. That I guess I needed to be clear on. So, but for whatever reason, as a customer, I demand a higher level of service. Yeah, I don't like customer because it denies a lot of civil rights. I like customer because customer is always right and the customer can make demands. I think that aspect of it is true. I want to keep away. There's no social contract with the customer, so I want to lay those two. I think that's a terrible analogy. Imperfect. How about that? Okay. So enough of the jibber jabber, enough of the prelude. Let's get right to the nuts and bolts here. So we got to file a few motions. I got a hearing coming up in front of this judge. Okay, no problem. You can see that because of the nature of the actions of this judge, we've sort of had to go down to the primal statutes here, okay? Let's recall, and this is where we're going to start out from. A administrative law judge, and I think thank you Huntington Township, is a attorney working for the governor of the state of Wisconsin, okay, or an Wisconsin ALJ, okay. They are called administrative law judge out of courtesy because the statutes have, and this is the administrative law judges in Wisconsin exist out of a statute, which is 227 is the chapter. And this is basically sets up administrative law. There's two sections there. Number one is how does an agency make rules? Okay. Have you ever been told by the DNR that you're not allowed to do X, Y, and Z, fishing, or I don't know what? Okay. Those are rules. That's not a law. Those are rules. Okay. The distinction there is a law is made by the legislature. This is in Wisconsin. Your vocabulary may differ. Your mode of government may differ. Those are laws. Frequently, because of all sorts of reasons, and hunting is a good one, for example, because the objects that are being hunted, they might say harvested, the objects that are being hunted fluctuate, right? There are differing numbers of deer from year to year, okay? The legislature is otherwise occupied, and also we know that there's no way they're going to make a law every year about how many deer can be shot. They're just not going to do that. So one of the solutions to that is to delegate that authority to an administrative agency. Now, there's a whole other side of administrative law that has to deal with administering money from the federal government and administering laws that the federal government attaches money to. We're not going to talk about that right now. We will talk about that at some other time. We got Lala the dog here scratching away. But I just want to note that and then move on from that. It's an extremely important topic, and people who want to talk about that, do not despair. We will get to that. But for right now, we're just going to talk about a locals issue and stay in sort of that mindset. Okay. So the legislature says we got to regulate hunting. You got all these deer. How are we going to, some years there's 100 deer, some years there's 200 deer. We got to figure out how we're going to do that. So who, what, where, when. We're going to create a body and authorize them to be in charge. Okay? No problem. That's a fairly simple concept, okay? And we have that fairly simply, for example, tourism board. Okay, I'm sure every state government, whatever, has some equivalent of this. We want to boost tourism in the state of Wisconsin. Therefore, we're going to create a board. We're going to give this board X amount of dollars. We're going to give this board X amount of powers to spend the dollars and to do X, Y, and other Z things. Mostly probably hold conventions and get, stakeholders, whatever they talk about, what they want for how they want this money to be spent. Okay? So that's the concept here. This is a board, this is a whatever, this is a something that's created by the government of the state government to do something, okay? Now, the second key part of the concept is anything that's created like that can only do what the legislature says it can do. Okay, there may be a lot of power. Regulate all the lakes in the state of Wisconsin. That's a lot of power. Okay, whatever. Regulate all the beer. That's a lot of power too. So there's a lot in a few words, for sure. But the point is that the beer regulator does not have the power to stop you in a traffic stop. Okay? Now, we want to compare that to the judiciary. Okay? This is the Supreme Court, the county courts, the appeals court in Wisconsin. You may have other things. That organization, the judiciary, all the court system is probably another word for it, is created by the Constitution, and it might be augmented by the statute, but because it's created by the Constitution, it has a significant number of inherent powers. In the same way that the governor of the state of Wisconsin has a significant number of inherent powers because of the Constitution. And why do they have, where does those inherent powers come from? In theory, from the sovereignty of the state of Wisconsin. What does that mean? The state of Wisconsin holds a lot of governmental powers for the health, safety, and welfare of its people. So it's legitimately allowed to act if it's acting in that capacity. If the state of Wisconsin was sovereign in terms of, I guess nationhood is probably the word we would call it here, but we can't declare war, we can't print our own money, we don't have sort of federal national powers. It's too complicated to explain, but we're sovereign in every way that matters except for in terms of taking care of ourselves. Nobody else can tell the state of Wisconsin how to take care of itself. Okay? Yada, yada, yada. I do not want to get into federalism. I just want to point out that because it holds the ultimate power, so to speak, that there are a lot of powers that are assumed in there. Okay? So nowhere does it necessarily have to spell out that a judge can put you in jail for disrupting the judge's court. Okay? That is spelled out in different ways, but that power is just inherent. Okay? In the same way that the governor can have you excluded from his meetings, there doesn't have to be a law that necessarily says certain things that are inherent to their office to getting the job done. Okay? That's in total distinction from the administrative agencies. By the way, the governor's powers are pretty limited in terms of, where he can act, but he can order sorry. It's turning into broad governmental things here. Okay. Concept got, history lecture aside, a governmental agency, the Department of Corrections, the Department of whatever, can only do what the legislature authorizes it to do. Okay? There's another concept here that's going to intersect here, which is bureaucracy. Okay? In Wisconsin, we have this classified system of state employees that are ultimately administered by an administrator, okay, otherwise known as an appointing authority. That person, not the governor or somebody else, has the power to hire and fire classified employees. So in theory, an ALJ could be disciplined, hired, or fired, demoted, whatever, by their administrator. The Department of Workforce Development, the administrator is Ramona Natera. Okay? Ramona Natera herself is under another appointing authority, and that is the Secretary of the Department of Workforce Development, Amy Petchacek. Okay? So Amy Petchacek appoints, hires, fires. If you can appoint, you can also fire. Ramona Natera, the administrator, Ramona Natera can hire, fire, whatever, an ALJ. Right, because ALJs are not elected. They are just government employees of the state of Wisconsin who happen to be attorneys, who are given hearing examiners, who are given this name ALJ. Now, The fact that they're ALJs comes from a Wisconsin rule. This is why we had to get into all that, and that's a rule is Department of Workforce Development Rule 218.02 sub 2. Okay, it's just a definition. It says hearing examiners at the DWD are going to be called administrative law judges. Okay, but they're hearing examiners, and hearing examiners is all of that is denoted by a statute here, which is Wisconsin Statute 227.46, hearing examiners, examination of evidence by agency. That's what we're talking about, workers' tribunal here. That's what we're talking about. This is a contested hearing. There's two different parties, and an agency is hearing the evidence and then making a determination. That is why Amy Petchacek's name is on decisions and notices for the Department of Workforce Development, because it's the agency, the Department of Workforce Development, an agent of the state of Wisconsin, right, by a secretary that's making these decisions, and the way that they're making these decisions is after evidence by a hearing examiner. That's a workers' tribunal in the state of Wisconsin. Okay, now back to the original subject, and oh my gosh, I'm sure we're some minutes into this. Only at 15. I mean, what do you got? Something else to do? Okay. 1 second. Let's just make sure that we know this other deposition when it's going live. Sorry. Thank you. All right. So, administrative law judge, there's a statute, and I just want to be clear. Statute is here, rule is here. Any conflict between a rule and statute always wins. Period, the end. Okay, statute is the will of the people of the state of Wisconsin as enacted by the legislature. A rule is just something that some guys made up who are working for the governor that went through a rulemaking process and like that. Okay. So let's go through the rule. We can put it on the screen, but I'm not doing that today. 227.46 hearing examiners, examination of evidence by the agency. Let's go to 1. Except as provided as 227.43 sub 1, an agency may designate an official of the agency or an employee on its staff or borrowed from another agency, yada, yada, yada. That's gonna be important. We'll talk about that. As a hearing examiner to preside over any contested case. Okay, we're just gonna unpack that sentence. Number 1, they can designate an official of the agency or an employee on its staff or borrowed from another agency. So an official is an actual ALJ, but apparently it doesn't actually have to be an ALJ. Okay? Now, number 2, borrowed from another agency. In this case that we're talking about here, because of Amy Petchacek's personal involvement in the case, as we allege, we have asked several times for a hearing examiner from another agency to be borrowed to help over. Now, that normally is the case. They recently did that. They had too many unemployment cases during COVID. They brought ALJs over for equal rights to look at unemployment. That's what they're thinking. We're saying, no, we want an ALJ from Department of Natural Resources, as is authorized here by the statute, to come over and hear this case because that person's boss is not your boss, is not an alleged bad actor in the case. That's what we asked for. Never responded. We asked Amy Petchacek. We asked the judge. We asked the administrator. No response. Okay. As a hearing examiner to preside, so that's the verb that they have, preside over any contested case. That's probably, does a judge preside? I mean, Judge Wapner presiding, right? Yeah, so that is a similar verb. Okay? It does not imbibe them with judicial authority, by the way. I'm going to do the old fake drink from the fake cup that has no coffee in it because it doesn't. Okay. Now, very important Very important. What do you call the first part of the sentence? Pre something or other? Jeez Louise, man. Where's your third grade when you need it? All right. Preside over any contested case, subject to the rules of the agency, comma. Okay. So whatever follows here, we know are subject to the rules of the agency. Okay. So they can do any of these things as long as the rules of the agency don't conflict with it. Okay. So we'll get into the rules. That's a separate thing. But remember, this is a statute. The examiners presiding at a hearing may, let's go through them because now it's going to tell may. That means, again, the key word there, they can do it if they want to. It's an important fact. It means that does imply a bit of discretion there, right? A, administer oaths and affirmations. Well, that's pretty important. You can't take testimony under oath if you can't administer an oath or an affirmation, okay? So that, just to be clear, let's say somebody's not a notary public and not allowed to administer an oath, and there just happens to be an old staff member, you know what I mean? Not an attorney. Let's say they're a hearing examiner from Department of Natural Resources that's not an attorney. I don't know. That person is now authorized just by the fact that they're presiding over the hearing to administer oaths and affirmations, regardless of what other status they may have. B, what did I like to think it was 2? Issue subpoenas authorized by law and enforce subpoenas under 885.12. Oh, don't you kind of wonder what 885.12 is? Let's see what that happens. I mean, it might be interesting. 885.12. If you give me an answer. Let's go over to C, though. 885.12, coercing witnesses before officers on board. If any person without reasonable excuse fails to attend as a witness or to testify, that's the sound of me remembering when an ALJ told me they couldn't do this. So, B, and enforce subpoenas under 885.12. And sorry, I'm going to start over. We're just like, take that rage, stick it down in there, smile. All right. If any person without reasonable excuse fails to attend as a witness, looking at you, Superintendent Posley, for example, looking at you, Chief Holiday, for example, I think we got others, or to testify as lawfully required before any arbitrator, coroner, medical examiner, board, commissioner, examiner, otherwise known as administrative law judge, committee, or other person or office authorized to take testimony or to produce a book or paper which the person was lawfully directed to bring, or to subscribe the person's deposition when correctly reducing to writing, any judge or of a court or record or a circuit court commissioner in the county when the person was obliged to attend, may upon sworn proof of the facts issue an attachment for the person, and unless the person shall purge the contempt and go and testify or do such other acts as required by law, may commit the person to close confinement in the county jail until the person so testify or do such act or be discharged according to law. Okay. Here's, I guess, the question. I'm sorry, I'm reading this in live time. When correctly reduced to writing, so let's go back here. This thing is, so first part here says, if any person without reasonable excuse fails to do this thing, okay, or produce paper, meaning testify in front of a commissioner, or to produce a book, a paper, or book or paper which the person lawfully directed to bring, okay, yada, 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 yada. Any judge of a court or record. Okay, we're going to stop there. Oh, I'm sorry you don't have this in front of you. I'm not going to go through all that right now. But it says enforce subpoenas. So this is the key question there. Does enforce subpoenas under 885.12 give them this power? Okay? Any judge of a court of record or a court commissioner in the county where the person was obliged to attend may, upon sworn proof of facts, issue an attachment for the person, and unless the person shall purge the contempt and go and testify or do such other things as required by law, may commit the person to put them in jail. So basically, have a show cause hearing, and if they refuse to testify, they can go to jail. Okay? I'm guessing that enforcing subpoenas means that they are able to issue a sworn proof of facts to a circuit court judge or a circuit court commissioner. It doesn't mean that the ALJ has the power to put somebody under close confinement. I believe there's some case law. We're not going to get into all that, but that's very interesting. It's more than, there's another power is if somebody doesn't come and show up, I can sue them. So if employer doesn't show, like a witness doesn't show up, the employee can sue them for civil damages for not showing up. But this says that the ALJ has the power to enforce subpoenas under 885. So maybe I'm totally misreading that. Who knows? Let's not get hung up on that anymore. But that is something to look for. The point is they can do it. C, rule on offers of proof and receive relevant evidence. Okay, that's the power. Hey, Lala, how's it going? That's the power that explains to them how they can say, hey, we need an offer of proof. Thank you. That, by the way, rule on offer of proof does not mean decide that something's irrelevant ahead of time based on your own personal belief. We've seen that, right? Rule on offer of proof means you have to give the person a chance to rule on the offer of proof, and then to make an offer of proof, and then you can rule on it. That's how that goes, not the other way around. And receive relevant evidence. So they can receive any evidence, but it has to be relevant. That's pretty low bar, remember. Anything relevant just has to be slightly related to a case. It's not much. Okay. It's a good fact. Point out, remember, it says may, so they also don't have to receive certain relevant evidence. That's what that says. Now, there's other rules about that and decisions and so forth, but just looking at that on its face, that's what it means. Here is the one I think that they feel is the catch-all that allows them to do whatever the hell they want. E, regulate the course of the hearing. Okay? So they feels that they can issue any orders ahead of time. They can do whatever they want. Okay? That's I don't believe that my understanding of what that means is at a hearing they can say this person's going to go first, this person's going to go second, you can't talk now, stuff like that. Gives them some judicial power that you would normally assume with a judge. Okay? Which is fair. I mean, if you're going to have a hearing, somebody needs to be able to manage what's happening on there. Okay? F, hold conferences for settlement or simplification of the issues by consent of the parties. And that's going to be really important here because, of course, Gelhard and other ALJs have tried to do this one here where they say, we're going to limit by decision the issues that we're going to allow you to talk about. Can't do that. But we already had an investigation and we had a certification to hearing. The issues that are certified to hearing are those issues which must be heard. You can't narrow down the issues because of whatever you want, whatever you think, Judge. You can't do that. Why? Because it says hold conferences for the settlement or simplification of the issues by consent of the parties. Simplification of the issues by consent of the parties. If a party does not consent to a simplification of the issues, then it cannot happen. That's what that says. Period. The end. Okay? And if you wanted to say that you had some power as an ALJ to simplify issues without the consent of the party, you would need to have some law or case that would back that up. Because right now, any plain reading of that statement says hold conferences for the settlement or simplification of the issues by consent of the parties. Or simplification of the issues by consent of the parties. Okay. Otherwise, if it would say hold conferences by consent of the parties for settlement and simplification of the issues, it does not say that. That or there puts the second or simplification of the issues by consent of the parties, right? Settlement doesn't need to say that because settlement is always by the consent of the parties. These are just simple rules of legal construction here. Dispose of procedural requests or similar matters. Okay, perfectly fine. If you got some procedural issue you want to bring, someone should be heard first, someone should be heard last. These issues should not be heard. Oh, can't do that. Why? Because you can't simplify an issue without the consent of the parties. That's what it says. Make recommended findings of fact, conclusions of law, and decisions to the extent permitted by law. Okay? Take other action authorized by agency rule consistent with this chapter. So, agencies, you can make rules, but it better be in conformance with chapter 227 that talks about hearing examination by hearing officers. Okay? So now, what did we just learn? We just learned that it's the state law of Wisconsin that administrative law judges only have 9 powers, and we went through all of those 9 powers. We thought through some examples of what that might mean, the limitations and the logical conclusions derived from what these rules allow. Okay? That's what we've learned. But we've also learned that any time an ALJ makes a decision or does anything, they need to be able at all times to point to one of these authorized powers, because otherwise, any decision that they make is, as we say, ultra vires, beyond the law. Okay, with that, they had no power to do it. Okay, so we'll get into some other examples. I'll save that for another few minutes here. We'll actually stop this video. I'll put out another one, and we'll go from there. But again, any decision that any judge makes, I don't care if it's Gelhard or anybody, has to be grounded in one of these 9 things. Now, there's some rules here that give them, number 9, which is F, gives HI, what the I, gives them take other action authorized by agency rule consistent with this chapter. It's pretty broad. So there's probably going to be about 20 other things there that ALJs can't do. Okay. So now we're going to get into their response when being confronted with the limits of their authority. Okay. It's categorically the same. It's Ben's fault. Whenever I did something that I cannot do, but it's Ben's fault. Therefore, I can do it anyway. There's your deafening silence. All right. We got more to come. Stick with us. We'll keep you informed. I just want to say one last thing, and thank you for that piano. I appreciate it. It's actually a very nice position to be in. I'm way more comfortable than a actual judge, where you only have 9 things that you can do and nothing else. And it must be a judge is way out there. Besides having to make decisions and everything, there's so much. They have a secret handbook, they have a public handbook, they have, ways of the law, they have guides. It's not like they're out there free, but in a lot of ways they're out there free floating. If somebody told me I had an inherent power, but I was not written down what it was or I probably would be very uncomfortable using it one way or the other, especially if there was going to be an appeals court was going to say, yeah, you misunderstood how inherent that power was or whatever. I mean, I would feel uncomfortable. And I think what we have here is the opposite situation where the judges feel absolutely comfortable defying these. They don't, this is not a touchstone or a basis for their work at all. And there's a culture of complete impunity. And it's that culture that we're not going to stand for. So today's today. We'll see what happens tomorrow. Stick with us. We'll keep you informed.